Welcome to the Colorado Trial Lawyer Connection, where Colorado trial lawyers share insights from their latest cases. The pursuit of justice starts now. Welcome back, everyone, to another episode of the Colorado Trial Lawyer Connection podcast. I'm Keith Fuicelli and am super excited to have on this episode Liz Hart and Melissa Hailey from Hailey Hart to talk about an absolutely phenomenal verdict that they received in Adams County. And some of the things that in talking with Liz and Melissa beforehand that I think are truly fascinating about this case are really the medical piece and how future pharmaceuticals and the need for future medications were worked into the case and the verdict. So I know that you all are going to get so much out of this, and I am super thrilled to have first-time appearances by Liz and Melissa. Welcome to the show.
Thank you, Keith.
Thank you, Keith. We're excited to be here.
All right. Well, I am so excited to be here because this is the first time that y'all have been on, and I don't really know either of you that well. So I'd like to start out by a little bit just talking about, let's start with you, Liz. What brought you into the world of plaintiff's work? And did you always know you wanted to be a trial lawyer?
I knew I wanted to be a courtroom lawyer. I'll say it that way.
Okay.
I was always interested in the law. And when I was younger, I read a lot of John Grisham novels and, in the 90s, watched Ally McBeal in The Practice. And I was like, wow, that looks really cool. They get to go to court and do all of these really exciting things. And, at that time, I really didn't know what any of this involved. But when I went to law school, my plan was to become a criminal defense attorney and start off being a public defender. And somehow I just kind of, in 2011, when I graduated from law school, I ended up at an insurance defense firm. And so I was an insurance defense attorney until about 2015, 2016.
Okay.
And realized that, in that time frame that I felt I was better suited for the plaintiff's side for a number of reasons, and made the switch, and really glad that I did that. And I really love it. I love being a plaintiff's attorney.
So let me ask you, for listeners that know they eventually want to end up doing plaintiff's work, when you look back on that experience doing insurance defense that was your first 4 or 5 years out of law school?
Right.
Was that invaluable? Is that, I was a prosecutor for almost 5 years, or other people can be public defenders. I mean, you got to get that experience one way or the other. Was it very valuable experience sort of working in the trenches that you would recommend it to others?
Yeah, I would. I felt very fortunate that I landed at law firms that had really, really good trial lawyers. My first couple of years of practice, I was at a firm in Kansas City with about 20 lawyers, and every case I was assigned to had either a senior associate or an equity partner on the case. And I got to work closely with them on all of those matters. And it was a huge learning opportunity. Because when you're the lowest level associate, you're given the responsibilities of digging through medical records and writing summaries and doing the first drafts of the motions to dismiss and the motions for summary judgment. And I felt that getting the experience to learn how to crawl before I walked was a huge building block in kind of, hopefully honing other skills on top of learning how to do just really the basics of building up a file. So I think that's really helpful. I think it's also helpful being part of those, closed door conversations with insurance adjusters and learning how they view plaintiffs, how they talk about plaintiffs' attorneys, things like that, and writing the reports to the insurance company, which, includes sections about not only the weaknesses of the case, but the strengths of the case and what we think of the lawyers on the other side. Do they have the chops to handle this case? So I think that experience is really helpful. But on the other hand, when I switch sides to plaintiff's work, you really have to switch your brain, because as a defense attorney, you're constantly tearing the case down, right? You're looking for these assumptions and you're looking for those opportunities to blow the cracks in the plaintiff's case wide open. It took a while to start to think like a plaintiff's lawyer and to build up a case and to kind of zoom out a little bit more and to keep that perspective. But I am very grateful for that experience.
Awesome. And tell us a little bit about your journey from, working insurance defense to now when you guys started your firm, and tell us a little bit about your firm, because I know it's been around for a fair number of years, highly successful, trial focused. So tell us a little bit about your journey and about your firm.
Yeah, so when I switched sides, I started working for a small plaintiff's law firm out of Boulder. It was a great experience. I really was looking for that sort of front of the house role in cases where I could try cases and do more depositions and things like that. And fortunately, I really was able to have that experience. And I spent about 5 years doing plaintiff's work for that firm. And then, I think it was COVID and spending a lot of time at home, and I had my daughter in 2019, and then I got pregnant with my son also during COVID, and, I was just when you have one child and another on the way and you're spending a lot of time at home, I was thinking a lot about what I wanted my life to look like in the next 5 or 10 years, and I, had this idea of finding a business partner maybe with a hopefully with a similar view of what things look like. I was hoping to create what would be a women-owned plaintiffs firm. I
Yeah.
think there are few of those, unfortunately, and the ones that are exclusively women-owned are typically solos. And I approached Melissa with the idea, and it really wasn't until I met Melissa when the idea really became something more solid. It was almost like she needed to be the other piece to this. So that was really cool.
So, Melissa, tell us a little bit then about what brought you to the plaintiff's world. And then eventually we'll get to this partnership with Liz. And one of the things I'll kind of cut to the chase on the partnership piece, but I'd like to sort of know what listeners should look for in a partner. Is it somebody that's exactly the same as them? What makes the ideal business partner? But we'll save that for the end. And let's start at the beginning. How did you come to be a plaintiff's lawyer?
Yeah, my journey was not straightforward. So I'm not somebody who grew up and always knew I wanted to be a lawyer. I didn't even know any lawyers when I grew up. Like this was just so
Wait,
outside
where'd you
of
grow
of
up?
my norm. So I'm just saying in my family, like there were
Oh,
no lawyers in my family. I didn't have any
okay.
family friends who were lawyers, no friends, you know what I'm
Yeah,
saying?
yeah,
So
yeah, yeah.
yeah, so I went to college and majored in conservation biology. So I was very much interested in ecology, ecosystems, wildlife, things of that nature. And
Yeah.
I ended up getting interested in law actually on a trip. It was a research trip that I took to Costa Rica after I had graduated and I was contemplating going off and getting a PhD, right? And
Ooh,
so I was with
okay.
some graduate students and we spent about 6 weeks in the jungle in Costa Rica. We were putting together a fire history of the Amazon basin, and I met so many people while I was there. And I felt very touched and moved by the ecological degradation that was happening in that area and how it was affecting these people's lives. And I left that trip with this very strong idea in my soul that I wanted to get into advocacy instead of research. And so that kind of, interest quickly turned into an interest in pursuing an education in environmental law rather than doing a PhD. So that's what I did.
Okay.
I went to school in Seattle to do a public interest environmental law focus with the intention of working for a nonprofit and doing public interest environmental law. And that's what I did when I graduated. So I spent the first 5 years of my practice. I was first licensed in New Mexico and then Arizona. I was doing public interest environmental litigation all over the country.
Wow.
So the substance of that work and the way those cases work is very different than what I do now. But what is similar is that I was, showing up in courtrooms, doing oral arguments, writing really heavy briefs, and taking cases from cradle to grave. But I was litigating against the Department of Justice full time. They were
Wow.
all federal cases. And unlike Liz, I mean, it's so interesting. And Liz and I are so different. And we'll talk about that in a minute. It's part of what makes us really good business partners.
Okay.
But I had a trial by fire, right? Like experience the first 5 years because when you're a staff attorney for a national nonprofit, right? And you're doing public interest work,
Yes.
you do huge cases all over the place. And frankly, Keith, like I was totally out of my depth, right? In my first 5 years of practice, like I'm at the Ninth Circuit, the
No
10th
way.
Circuit, the DC Circuit Court of Appeals, like doing all of
Wow.
this insanely intense stuff, right? But, you know, what that does is it like builds confidence
Yes.
and
It's like
the
David Scoggins. It's
exposure.
like you can do hard things. You can do hard
Yeah.
things. You did hard things. So you come out of that and you're ready to
Yeah.
roll. That's awesome.
Yeah. So it was a really interesting experience. And more than anything, I have a really strong writing background and I got so much writing experience in federal court doing that type of work that's really been helpful to me. But to kind of cut to the chase of how I got to where I am now,
Yeah.
I literally like ran out of funding. Those jobs pay very, very little. I
Yes.
mean, my
Yes.
first job as a lawyer, I made 32,000 a year.
Yeah.
So, I went to DU, which is private. I went to Seattle University, which is private. Just the financial kind of realities of that caught up with
Sure.
me a little bit. And
Sure.
I took what I thought would be a detour into this kind of work, and I found a home here, and I love it so much that I stayed. So
Awesome.
I kind of transitioned, my environmental interest and channel that in other ways. But for my day to day, this type of practice is really where it's at for me. There's more variety, more discovery opportunities, more depots, more trials, and it's just been a blast.
Awesome. So, little known fact, I actually majored in environmental conservation. And I actually
There you
wanted to
go.
go the route that you went before I realized, at least in my worldview, how terribly boring that route was going to be. And so I pivoted pretty quickly and went to law school and then became a trial lawyer. And like Liz, I grew up with the practice, Law and Order, Ally McBeal, John Grisham. I was out to dinner last night with my father and we were talking about John Grisham books. And it is the one thing, if I go on vacation, I will like, if I have a John Grisham book, it's the only thing I can't put down and I read it in like a day and a half. And he is a good writer. I'm just going to say, go on the record. He is a phenomenal writer. Okay. So Melissa, tell us a little bit then, how long have you all been business partners? When did your firm start?
Yeah, our firm started in February of 2021.
Okay.
So we were right after COVID, as Liz was saying, like this idea was kind of, a COVID baby. People talk
Yeah.
about COVID and say so much of the time, like that COVID was a mirror, and
Hmm.
it certainly was for me. I was having a similar experience as Liz. I was at home and really kind of looking at my life and going, what do I really want my life to be? At the time, though, I had a great job. I mean, I was working at Keating Wagner.
Yeah.
I had been there for 5 years. I mean, I was working with the best PI and bad faith lawyers around, in
Yeah.
my opinion, and doing really great work and working on really big cases. And so, I mean, I wasn't looking to exit, but this lovely lady, who is a spectacular lawyer and a spectacular human, approached me and we started talking. And once that seed was in my head about business ownership, and the creativity and the autonomy that could come from building something from the ground up and having it look just like you want it to
Yeah.
with a person with shared vision, it was so exciting to me that there really was no way to say no.
So I know we have some younger lawyers that listen to this podcast that have that thing in their brain about starting a firm. What would your advice be to anyone who's thinking about starting their own law firm? We'll start with Melissa, and then we'll come to Liz. And for our listeners, we didn't talk about this in
Yeah.
advance. This is on the fly. What's the advice you would give Melissa to someone who's thinking
Yeah.
about starting their own firm?
Gosh, Keith, I think if you asked 100 people that question, you truly would get 100 different answers,
Yeah.
right? Because we all have different values and priorities, and we all have different risk tolerances.
Very true.
So
Very true.
I will say, starting a law firm, on the one hand, is very easy, right? Because
Sure.
it's not like opening a restaurant. It's not like opening a retail store. You don't really need much other than like a laptop and a Westlaw subscription. You know what I mean? Like you can physically start a law firm almost anytime, anywhere. My advice would be don't focus on the logistics because that's the easy part, right? Focus on why you're doing what you're doing and, what is your long-term goal? Because contingency work and having your own firm is not for the faint of heart. This
Amen.
is this is this is hard. It's
Amen.
hard.
Yeah.
It's scary. It's joyful. I mean, Liz and I had so many just very real, transparent conversations about risk and contingent plans. And I remember very clearly a conversation once we had really decided to pull the trigger. And I was like, all right, buckle up. Like, this is going to be all the things.
Yeah.
And it is all the things. We're coming up on 5 years. And
Congratulations.
thank you. I think 5 years is probably really kind of, the sweet spot. You got to work out all the wrinkles and figure out like who you are and what your firm looks like and how you want to do business, all of that stuff. I feel like now we really have like just a wonderful team in place. We've got our groove, we've got our rhythm. I feel like we kind of are who we're going to be at this point in time. And all the really scary stuff is worked out.
Love
So
that.
but yeah, my advice would be do your research and really rely on your resources. And I know a lot of people get out there as solos and, God bless. I respect the hell out of that. That's not for me. True partnership and teamwork brings out the joy of the practice of law.
Yeah.
And that's so important to me. So, I would always advocate for excellent teammates if you can find them.
And speaking of excellent teammates, Liz, what are your thoughts on sort of any advice and sort of what does an ideal partner look like from a law practice standpoint?
Yeah, and I just have to add to the love fest. Melissa is one of the most amazing people I've ever met. We didn't know each other very long at all before we decided to go into business with each other, which is
Wow,
kind
I
of
love
insane.
that.
I only knew her for a couple of years, but I tell people I make decisions about people very quickly. I don't know what it is. With Melissa, when I first met her, I was like, I love her and I want us to be friends. I wanted her in my life in some way. And we started hanging out with a couple of other really wonderful lawyers who were part of WTLN, and we got to know each other on a personal level. And then when the decision came, I was like, well, I don't want to be a solo. I want to find a business partner. And Melissa just popped into my head right from the beginning. But we are two very different people. And that's something that we've learned over time. But you have to find someone who you respect deeply, that you trust completely. And one of the things we talked about before going into business with each other, and we talked about money. You
That's
got to
so
talk about
important.
money
So important.
because, I mean, as business partners, we work on cases together, but 80% of our conversations revolve around money, how the firm is spending money,
Sure.
where we want to spend our money. And there's been some very, dynamic conversations around how the firm spends money, and you have to be able to talk through those. So we talked about how we personally handle our finances. We talked about personal debts. We talked about standard of living because we wanted to make sure that one person isn't thinking, I want to make, and I'm just going to use funny numbers here, I need to make $50 this year. While the other one's saying, if I make $20 this year, I'll be pretty happy and I'll kind of coast. You kind of have to have similar financial goals. So one person isn't saying, I have to make, I have to make a 7-figure income consistently for the next 20 years because I like to buy X or whatever it is.
Right.
This is how I like to spend my time. Because if you have two different views on how you spend money and what you need to maintain a standard of living that's comfortable to you and your family, then that's a very difficult road for two people to go into business together. So what I would tell anyone thinking about going out on their own and finding a business partner, you have to have really hard conversations about money, and you have to talk about your personal finances and what you need for your family to have a different, to maintain the standard of living that makes you comfortable.
It's such great advice for our listeners. And with that, let's jump into this amazing case. So I like to sort of, cut to the chase. This is a $7.6 million verdict in Adams County on a car crash case. So before we sort of talk about some of the medical pieces that I do find fascinating, Liz or Melissa, which one can sort of give us well, first of all, before we jump in, I'll ask Liz this. How did you break up first chair, second chair? How did you guys divide up trial responsibilities on this case?
Yeah, so we don't really call it first chair or second chair
Okay.
because what we try to do, and this is kind of the spirit of our firm, we approach everything as a team. And when Melissa and I, the way that we have approached trials in the last 4 years, and we just kind of divide everything down the middle.
Okay.
So I typically do jury selection. Melissa does the opening statement. Then I usually take the first witness, and then she takes the second witness, and we
It's
try to keep we're
literally right down the middle.
we're
Literally.
trying yep, we try to alternate witnesses, but of course, it doesn't always work out that way because you have to shuffle people around, and it's fine. And then I close, and she does rebuttal closing.
Okay.
So we try to just split it right down the middle, and we try to have the jury hear from us equally, if
Okay.
possible. Because I think, at least my experience has been, if you have two lawyers who are showing up to try the case and one lawyer is kind of in the background, I think when you have two attorneys showing up, demonstrating this passion on a daily basis for the client, I think that it can just be a little more persuasive that way.
Okay. Love it. So Melissa, tell us the facts of the case. What happened?
Sure. Pretty straightforward. So this was a car crash that happened in November of 2019. Our client was a young lady. She was only 16 on the date of the crash. This was, no weird facts, right? It's a Friday afternoon. It's 4 o'clock. The roads are clear. The sun is shining. Our gal was coming home from school. The woman who hit her was in her 50s. She's just a normal person. This was in Commerce City. They both lived within 1 mile of where the crash occurred.
Okay.
Defendant driver is trying to turn out a King Soopers. She's done her grocery store shopping. She's on her way home. She's sitting at a stop sign, waiting to turn left across traffic. Our client is going south, approaching that stop sign. Defendant driver pulls out right in front of our client
Yeah.
and causes a collision, right? She pulled right out in front of her. No opportunity to avoid. So it's a T-bone crash. The crash, this was not like mangled vehicles by any means, but the force was enough to cause our client's frontal airbag to deploy.
Okay.
And her face went into that airbag, and she did not have any orthopedic injuries, but she was complaining of head pain and face pain at the scene.
Okay.
She wasn't emergently transferred, but she did end up going to urgent care that night because she continued with a headache and she started vomiting.
Wow.
And
Okay.
she was diagnosed with a closed head injury the night of the crash, sent back home, and then continued with these symptoms that just did not subside through the
And
weekend.
no real imaging at urgent care, I'm assuming.
No imaging at urgent care. The imaging that she ended up having down the line was all
Of
unremarkable.
course.
So, there was a pretty typical trajectory of treatment in that she seeks out some conservative care. She does PT, she goes to a primary care physician. And this is a young girl, right? So she doesn't have like a huge medical history. She had some history of minor headaches. They were typically around her menstrual cycle. This was the kind of headache she called them normal person headaches, right?
Okay.
You pop an Advil, you're okay. She didn't have a history of migraine or anything like that. She ended up going to neurology about 9 months after the crash, and then she consistently treated with a neurologist until the date of trial. She will continue to treat with a neurologist for the foreseeable future, but she was ultimately diagnosed once she got to neurology with a chronic migraine condition. So she was suffering from two types of headaches, migraines and cervicogenic headaches,
Okay.
and those were projected to continue for her lifetime.
So back up a little bit. How did your client get to the neurologist? Did you all help facilitate that, or was that solely on your client's own doing to get in to see a neurologist versus just sort of living with it?
That was her own doing. She did not contact our office until, I guess it would be 3 years after the date of the accident.
Like right before the statute, you guys?
Well, the statute told because the
Oh, right,
accident
right,
happened.
right. Okay. Yeah. Okay.
Yeah, so she had time, and her mother was handling the claim with USAA up until that point,
Okay.
and they realized that this was becoming more than what they expected, with her going into neurology care and the symptoms persisting, and they ended up contacting our office in late 2022, and by that time, she had started neurology care. She actually started neurology care at Children's, and then she transitioned to adult care, at UC Health, and it was a couple months after she transitioned to adult care when she contacted us.
Okay. I mean, what a perfect sort of setup for the case coming to you all. You all get involved. Did you reach out to USAA to try to get them to pay? What were the limits, and did you make efforts to try to? And Melissa, I don't know if you want to cover this sort of. What were the
Sure.
pre-filing efforts made to try to get USAA to do the right thing?
Yeah. So, being 3 years out from the crash and having been in neurology care at Children's and then transitioned to adult care at UC Health, we really felt like when we took this case that it was going to be with us for a fairly short amount of time,
Sure.
right? So we did not think this was a case we were going to have to file. And so, yeah, I mean, our initial plan certainly was to submit a policy limits demand to the liability carrier that was well supported, explaining why they should pay the limits and we should all move on with our lives. So, what we did, because she was treating at UC Health and her treating neurologist, who did testify at trial, is a doctor named Dr. Danielle Wilhauer.
Okay.
She's not only a neurologist, but she's one of only a handful of headache specialists in the United States. We reached out to her. She was always very willing to talk with us. And we got a report from her pre litigation explaining the condition and explaining that our client needed what are really honestly very expensive medications moving forward. So, one thing that I think is important to understand is our client tried a whole host of medications
Okay.
over the years trying to get her headaches under control. And it wasn't just medications, it was other therapies. But what worked for her, finally, after years of trial and error, is an infusion medication that's called Vyepti. And it's a fairly new
What's
medication.
that? Repeat
And
that.
it's
Vyepti. How do you spell that? If you
Vi-
know.
it's Vyepti.
Okay. Vyepti.
And Vyepti is an infusion that's typically given every 12 weeks, so it lasts about 3 months, and it's given at an infusion clinic, right? So similar, think about how kind of a chemo
Yeah.
treatment is given.
Okay.
That's about how it works. Our client has to go to the infusion clinic. She's there for about an hour. She typically feels tired afterwards. But this preventative medication, and we don't need to get into the science, certainly Dr. Wilhauer did, but it actually binds with a receptor in the brain and locks up that receptor. And in that way, it prevents migraine symptoms. So
Wow.
it's a very cutting edge treatment and it's very effective. So we had Dr. Wilhauer talk about Vyepti in her report and explain that she thought our client would need it for the duration and how much that would cost. So essentially, we were able to show USAA we've got a very young girl here who was hurt and she needs millions of dollars of lifetime care. And we'd like the policy limits of $300,000, please. That feels like a pretty easy lift, but obviously we're here and it just didn't go that way.
USAA says, well, your client's past medical bills are $20,000, right?
Our past meds at that time, I think, were over 100,000.
Okay. From the medication, how much of
Yeah,
that was the medication? Significant?
a good deal of it was medication, but it was also things like doctor's visits. She had done physical therapy, she had done chiropractic care. I mean, this girl had been in treatment consistently for years
Wow.
by that time.
Wow.
But, USAA did value the claim. They came up with a number
But
that
it was
had a
not
decimal
300.
point in
It
it.
was not
Sure
300.
wasn't.
All right. So you get the offer. Liz, talk to us a little bit and really to our listeners about the importance. What I'm hearing is that you all worked this case up marvelously before you put it into litigation. You're talking to the treating doctor, you're getting a narrative report, you're pricing all of that out before. So how important and critical is that in your success? Liz, what do you think about that?
I think that, well, it certainly didn't move the dial for pre-litigation settlement, but it certainly put us in a really good position to later send a demand to USAA for extra contractual damages. So when we were working this up pre-litigation, knowing that, we were sending over, 6 figures worth of medical expenses with a $300,000 policy, we decided to go ahead and reach out to our client's treating neurologist who has a fellowship in headache medicine. And there's very few neurologists in the country who actually have a fellowship in headache medicine. We got a letter from her and it laid out her treatment plan and said that this is a lifetime treatment plan for this girl.
Wow.
And we submitted that to USAA and they said, no, we're not going to give you the 300,000. And so we gave them a second chance to pay the 300,000 pre-litigation, resent the letter from Dr. Wilhauer, still didn't pay it. And then what that essentially did was set us up for, after we filed suit, which we told USAA we would not entertain a policy limits offer after we file suit. So we filed suit, and then after we got through expert disclosures and the case was looking very strong at that point, everything was supported to the gills. We sent a demand for extra contractual damages to USAA. And having that history of showing that we worked it up in litigation, but we really did our homework before we even filed suit. And we
Yeah. Yeah.
demonstrated it's a permanent condition for a girl who was a teenager at the
Yeah.
time,
Yeah.
who's going to need very expensive headache and migraine pharmaceuticals for the rest of her life. Having that history under our belt to posture this case for, and I've seen people say the policy is open or something like that. The insurance policy is now open, but putting us in a position where we can confidently pursue damages above and beyond the limits was critical.
Yeah, I think Nick Raleigh would say in your case, the policy is open for sure.
Maybe that's where I saw. Yeah, I did not.
No, I think your policy's open. You guys are marching forward. Melissa, I feel like me personally, have had hit or miss success with UC Health doctors talking and cooperating. What's been your experience? Obviously, here you had someone. It's so critical when you have a situation like this where you have a treater who's phenomenal, well credentialed and willing to help. Did you experience any resistance? You guys are so nice. And what advice would you give? This is a serious question. What advice would you give lawyers on how to breach that gap to get to the person and it could be a Kaiser doctor, it could be UC Health. What advice would you give lawyers, including myself?
Yeah, I think that's such an important question. It doesn't hurt to be nice for sure. But what's more important, I think, my advice would be work it up early. I don't care if it's a PI case or any other kind of case. I think, when a potential client walks in the door, and this is certainly a philosophy of our firm, do your homework and figure out who your team is even before you sign up the client, right?
Yeah.
Because the team is everything. And the team includes the lawyers, the client, the groaners, for lack of a better word,
Yeah.
sorry,
Yeah, I know.
and all of the experts who are going to come in and meet your burden of proof for you, right? So, even if we're not in a situation, where in this particular situation, we would have always tried to reach out to the treater pre-litigation, right? And
Yeah.
try to develop a relationship. So my advice is you want to find out as early as you can who the key treaters are. And you want to reach out and see, are these friendly folks who are going to work with me and my team
Yeah.
to do the things that we need to do to help our client. And if they won't help, that's fine. I am not the kind of person who's going to bring a doctor in kicking and screaming on a subpoena. Liz has a story where that actually worked out for her once. Back in the day, she brought in two treaters totally blind
Wow.
on subpoena
Okay.
and examined them at trial, having never spoken to them again, and it went beautifully. I'm pretty conservative when it comes to that. I'm going to avoid that if I can, because I've certainly had witnesses at trial who didn't want to be there. And 90% of the time, they are not helpful, right? So, if you need to bring in an IME doctor because you don't have a treater that's going to participate, you need to know that early. If you get lucky and you find a treater who wants to talk to you, then you've got enough time to really develop that relationship. And developing that relationship means calling the office, making a traditional appointment, going in person and sitting down with that treater and having a face-to-face conversation after you have reviewed the records and you are able to have an intelligent conversation about treatment.
That advice is so critical to do the time, sit down, do your homework beforehand. I cannot stress how, in my personal opinion, that is so critical. And one sort of follow-up question is, I know in this case, you also got your own IME doctor. So what was your thought process? You've got a treating doctor who's willing to play ball, sounds phenomenal, and then also go get an IME doctor. What was your thought process? And obviously it worked out given the verdict, but how critical was that to your success in this case?
Yeah, well, we knew this was a case that was headed for trial, right? For all the reasons we've already discussed. So when we got to the point of expert disclosures, we're really thinking about trial presentation.
Yes.
We knew that Dr. Wilhauer, our treating neurologist, was going to testify. However, we don't want to put too much weight on any one of our witnesses. We really wanted to make this experience as pleasant as possible for her, and we wanted the subject matter that she was going to address to be as narrow as it could be so she could really shine on those areas where we wanted her to present. We did have past medical treatment, right? So our client had treatment before she saw Dr. Wilhauer. And so we wanted to bring in the IME doctor to do two things: to really be able to talk about the past medical treatment, right? And go through all of those records that Dr. Wilhauer wouldn't necessarily have wanted to go through one by one. That's really outside of her bailiwick.
When you say past, you pre-crash or just before she got to Dr. Milhauser?
The latter.
Okay.
So the IME doctor did go through pre-crash records, of course, because we needed to
Because you mentioned there
establish.
was some like minor headache, take some medicine type things. Okay.
That's right. We wanted our IME doctor to be able to look at those records and say, one of the questions we asked: are the new headaches related at all to the old headaches? Is this a different beast, or is this a continuation of something that was pre-existing? So he was able to address that. He was also then able to testify about her medical treatment up until the point that she transitioned to care with Dr. Wilhauer. And, frankly, we weren't really sure how far the court would let us go on kind of a rubber stamp of Dr. Wilhauer's opinions. But Dr. Wilhauer is a younger woman. She
Okay.
is eminently qualified, but she's in her late 30s. She's young,
Sure.
right?
Sure.
And Alan Bowling, who was our IME doctor, is an older guy. The credentials are insane, and he is typically a defense IME doc. And so we wanted to call somebody who usually works for the other side
Yeah.
and say, give it to us straight. We want you to look at everything and tell us if our case is strong. And Alan Bowling, this conversation happened with Liz, but he told her, I am very skeptical of these cases. I look at a number of these things, these chronic migraine cases,
Yeah.
they're typically bogus. So I'll look at it, but I probably can't help you. And he looked at the records. He met with our client for an in-person IME, called us back and went, your client is one of the most credible people I have ever seen in my office.
Wow.
I 100% think that this condition is real and happy to be on your team. So there was a little bit of overlap between Dr. Bowling and Dr. Wilhauer, but it really inured to our favor because, of course, the defendant got their own neurologist IME. And so we had kind of this head-to-head thing with Dr. Bowling. And then we were also able to really bring in Dr. Wilhauer and talk about her personal, right, encounters
Yeah.
with Melissa Day, our client.
So, Liz, question for you, because we have handled a lot. It seems like a lot of these post-concussive syndrome type cases are, and at least here, sort of morphing into headache cases more than they are post-concussive syndrome. So Melissa mentioned that your retained expert who works for the defense a lot says that, in his opinion, a lot of these cases are bogus. So, Liz, what should people be looking for as red flags in ongoing migraine headache cases? Like, what are green flags and what are red flags based on your experience?
Yeah, so I've done a handful of these headache and migraine cases, and I think one of the difficulties of these cases is that, a headache and a migraine don't show up objectively. It is a pain complaint at the end of the day. If someone is suffering from a headache or a migraine, they're feeling pain in their head. And we don't have something that we can show the jury to say, look, there it is. There's the headache that she's having in this moment. And especially, in this case where the underlying cause is the MTBI and we have unremarkable imaging throughout her course of treatment. But one of the things that was really strong for this case is our client was 16 years old when this happened. She's a younger woman, and there was an immediate onset of the head pain. And we also had a closed head injury diagnosis on the day of the crash. And Keith, you know this, that almost never happens.
Right. And you had vomiting too.
Vomiting. So it was a severe and immediate onset of symptoms, and that doesn't always happen. But I think what you really have to look at with these cases is how the client presents and whether they come off as being credible. And we can always say, us as advocates, we believe our clients and we will always believe our clients. But that doesn't mean everyone's going to believe our clients, especially when there is a pretty huge monetary ask at the end of trial. Jurors are going to look critically at the case and they're going to do it very intentionally. I really think the headache and migraine cases, the real value is in the credibility of the person talking about it. And then obviously pre-existing conditions is, you have to really look into that as well.
Sure, sure. So, Melissa, I know from speaking before, the verdict was broken up as about 7.1 in economics. So clearly for the migraine headache medication and about 4 or 500 in non-economics and nothing in impairment. Tell us a little bit about how you let this Adams County jury come to the conclusion like, yeah, it's $7 million, but it's just economics. It's just for the medical. Were there sound bites that others could potentially use on asking for such a huge 7-figure economic award for future medical care that the jurors are probably thinking, well, it's going to be generic in a couple years, or they'll come up with something better, but they gave you to the penny what you asked for in economics? That is a monstrous number. How did you do it? It's so awesome.
I don't have a short answer for you because this was the whole case. The whole case was we are putting our eggs in this future economics basket, and we need to identify all of the reasons why the jury might say nope, or might say not good enough, or we want to split it in the middle. Because when you've got a driver on driver situation with no truly egregious facts, there
Yep.
was no real bad actor
Right,
in this
right. Yep.
case. No one hated Wanda Massey, the defendant. She made a mistake, okay? And so we knew that the jury was going to be trying to resolve this tension between wanting to help our client and not wanting to destroy the defendant. And so where does that land you? Typically, it lands you somewhere in the middle of what you ask for. And that was not the result that we wanted. We wanted the jury to be able to go all the way. So one of the things that we did that was truly helpful in honing our strategy was we hired John Campbell to do a big data survey with this case.
Yes.
And we were focused on damages. And so some of the questions we asked were these. What are all of the reasons why people are going to give us less than 7.1 million in economics, right? What are all of the arguments, right, against giving us what we want there? How does permanent impairment fit in when you've got a case where you're saying, we really, really need this treatment because it really, really helps, yet we have a permanent condition and she should be compensated for that? How do those two things play together with jurors? And what about non-economics? Because here we were capped at 460,
Yeah.
right?
Yeah.
And so we were trying to figure out, our numbers are big. And so do we even want to ask for non-economics, or is that going to skew us in another category? Because what we didn't want, number one, we wanted to know why are all the reasons why 7.2 feels like the wrong number for economics? And number two, what are all of the reasons why us asking for different damages categories might pull from that category that we've clearly established, right? And so that was where we were focused with John Campbell. And he did an excellent job and gave us some data that was very, very helpful in helping us decide, number one, how should we be asking for damages? What are the numbers? And then what are these jurors probably going to have on their minds as to why 7.2 is the wrong number? And we went at it head on. That was our whole case. So we identified, like, here's the arguments that we know. Even if the defense isn't going to say it, we know what the jurors are going to be thinking. And we went at it every single time. We went at it in voir dire. We went at it in opening. We went at it with our witnesses. We went at it with closing. We made those problems. We made the anticipated defenses against the 7.2 the key themes of our case, and we repeated those themes over and over and over again.
And just so our listeners are clear, you helped get those with John Campbell and big data that gave you
Yes.
sort of what those resistance points were. And I guess I'm curious if that data told you to back off permanent impairment. So when you all were doing closings, were you like, look, this is a really big number, but this treatment works. So if you don't want to award impairment damages because of this treatment, that's understandable. A, Did you guys make some kind of argument like that? And B, if so, what was the language that you used to sort of give the jurors the okay to give you 0 in impairment so long as they gave you 7 figures in economics?
Yeah, I'm gonna let Liz address it because she's the one who actually went over the final numbers asked in closing.
Okay.
Yeah, I mean, I think we probably spent, so we had 30 minutes to close, and I probably spent, time becomes a weird thing when you're standing up and closing, so I don't really know how much time I spent on it, but I felt like I spent the majority of my closing on the ask for future medical treatment. And I'm going to kind of back up a little bit. To add to what Melissa was saying earlier, what we also found out, so we only asked for the 7.1 million is only the cost of the trigger point injections and the Vyepti treatment over her lifetime. It doesn't even have to do with she has to take propranolol every day, duloxetine every day, and there's also a number of rescue medications that she has to take to head off her headaches and migraines. And we didn't include the cost of those because our numbers just got to the point of ridiculous at that
Okay.
when we included everything. And Melissa and I were struggling leading up to trial thinking, where do we start looking ridiculous? And that was also one of the reasons we brought John Campbell in. And what we found was when we asked for anything over 11 million, we started getting diminished returns on our damages.
Okay.
Started getting into that like you're silly range. And so we had to kind of craft our strategy to try to not get over that. And so we stuck to the trigger point injections and we stuck to the Vyepti. And the way that we went at it in closing and the way that we wove the themes throughout the witnesses is that number one, we had Dr. Wilhauer explain to the jury, I'm the headache person, and I'm going to tell you what's up, which is this is a very standard treatment regimen. I'm not doing anything special for this person, for Melissa and Liz's client. This is standard. This is typical. I prescribe these all the time, and I've got 200 patients under my care, and 100 and it was like 120 of them are on Vyepti. This isn't anything special. This is just what it takes to treat something like this. And this is just what it takes to get these people functional in their day-to-day life. So that's one of the things that we talked about in closing. We were like, look, she didn't ask for headaches and migraines for the rest of her life. This is horrible. But you heard from Dr. Wilhauer, she sees these people all the time. There is nothing unique about what we're asking you for today. There's nothing special. This is not a luxury treatment that we're asking the jury about today. This is what it takes. This is standard and this is reasonable. And that is our standard that we have to meet for the burden of proof. So that was one of the things that we were really drilling down on in both the neurology testimony and also in closing.
We spent so much time talking about the damages because Liz is absolutely right. Once we put everything in, it was like monopoly money. And the last thing you want to do when you've got a great client with great credibility is go in front of the jury and risk that credibility by asking for too much money, even if you can support it, because at the end of the day, this is a headache case.
Yes.
And 8 figures for a headache case is really hard, as we found out. We suspected it and then was confirmed, is really hard for people to get their arms around. So we found ourselves in a very unique position running up to trial of going, we've got to bring our numbers down.
Wow.
Where do we want to take away? And Liz is absolutely right. One of our main strategies was to say, we are trying to be as conservative as possible. This is not a woman who's here trying to get a big jury verdict just because she can. Here's all of the things that are prescribed to her over her lifetime. We're only asking you for 1 and 2. And we explained to the jury why those 2 things, the Vyepti and the trigger point injections, were the keystone of her treatment. You can't do it without these 2. And they were also the 2 that she had to go in clinic for. They're actual medical procedures. It's not something that she's carrying around with her. She has like a wearable device, all this stuff. But these are actual medical procedures that she's going to need, and they would be performed by Dr. Wilhauer. But it was kind of crazy like that. And I think that it's really important for everyone trying cases to be really realistic about when you do have big damages. Is there a tipping point here where if we go over it, we might start to be working against our own credibility. Like, don't make problems for yourself, right? Be realistic about what a really great outcome is and move in that direction. And that's what we did here, and it really paid
I
off.
mean, it's amazing, amazing outcome, and sort of big data helped tell you where that overreach was. So my
Right.
question to either of you is, how did you deal with the impairment piece? Was there specific things you said in closing to give the jurors the okay to award zero if they gave you everything in economics? And that is a question for both of you, because I am so enthralled by what an amazing economic result, and the zero impairment seems to make logical sense. So I'm just wondering if you kind of address that head on in closing, either first or rebuttal.
I'll give one kind of set the stage comment and then let Liz address how we actually did it in closing. So, the set the stage comment is we wanted to give the jury options because we knew that despite our best efforts, right, juries do crazy things all the time. And sometimes, you just might end up with some people on the panel who just aren't going to go there with you. They're going to say, this medication is too expensive, and they're going to want to speculate, right? And we
Yeah.
covered all of that, but people are maybe going to want to go there. So we wanted to include an ask for permanent impairment just in case our jury wasn't with us on the economic ask so that they had an outlet to put that money somewhere else. So we were trying to give the jury options of how they might make our client whole. And with that, I'll let Liz talk to you about the closing.
And I am so enthralled because this, I feel like, is brilliant, that it's either this or that, all ending up with phenomenal results for your clients. So Liz, how did you, with that stage set, how did you sort of give these options to the jurors for them to choose? Is it, door one, door two, or door three, all of which are great for your client?
Well, I'll be totally honest with you, Keith. I asked the jury to award $3.5 million in permanent impairment damages, and in addition to
Okay.
the $7 million for the future medicals. And the reason we did it that way is because our client, even when she's on the Vyepti and the trigger point injections and you know, the other 10 medications that she needs to have with her at all times, she still has breakthrough headaches and she still has low level head pain, and she will also have, on occasion, a migraine. When she was testifying at trial, she did a great job explaining to the jury how great she does when she's on all of her medications and she's following the treatment plan. And so the jury just decided on their own, because I said, despite all of this medication, we still have these breakthrough issues, and she will be dealing with them. And when these things break through, it impacts her life. But what they decided was, well, we feel really comfortable having this person pay for her medical treatment. And it sounds like when she's on her medication, that she doesn't really have much impairment at all. And also, and we talked to the jury. Unfortunately, we had an hour to speak to the jury after the trial. But
Wow.
they thought this is also encouraging for her as a young person to stick with her medication regimen if we pay for this and we fund it for her lifetime versus giving her money for having her life be impaired. And so they sort of saw it as a tool for encouraging her to continue to follow her medical treatment plan and to spend the money the way that she is supposed to.
Okay. And we're coming up on the end of our time. I kind of like to keep these right about an hour. Who is your judge, Melissa? This is Adams County. Who is the judge?
It was Judge Pugh.
Okay.
And our case was originally assigned to a different judge and was transferred to Judge Pugh, gosh, 3 months, if that, before we were set to try the case. And he was a total unknown to us. We really didn't know what to expect. But I do want to go on your podcast record as saying Judge Pugh was excellent.
Great.
And I would be enthusiastic to try another case in his courtroom.
Oh, I just love anytime we hear anything like that, it warms my heart because, too often I feel like we hear sort of the opposite, but to hear a judge out there is letting you try your case.
Yes.
Adams County, sometimes I get worried about Adams County not appreciating the value of money, but clearly not an issue here in this case. And anything else that, Melissa, you remember from speaking with the jurors an hour, for an hour afterwards? Were there like crazy visuals you all used or any demonstratives that really landed?
We didn't use a bunch of crazy visuals. We tried to be pretty conservative with our demonstratives. Certain things worked and certain things didn't. I'll tell you some like kind of fun facts of things that didn't really land with them. We were really focused on function during the case, and we spent a lot of time like putting together a pain scale with our client and kind of how that, translated to function. We were really excited about it. We used it with our client with her testimony. The jury was kind of like, take it or leave it, right? So that didn't work so well. They also they didn't love our before and after witnesses,
Oh,
who we thought were great.
okay.
But they had decided, if she gets the medication, her function is going to be good. So hearing stories about how her function was impaired before she got on the Vyepti, they just thought kind of was a waste of time. So that was a really interesting takeaway.
Yeah, yeah.
Yeah, one thing that really surprised me, we were very concerned about them wanting to, not wanting, but being willing to award a big verdict against an individual defendant. And they weren't really concerned about that. I was so surprised. We really asked them, like, did you struggle with awarding these big numbers against an individual defendant? And they were all like, no, didn't really bother us. The numbers were supported and we feel really good about it. So that was surprising.
That is surprising that none of them were like, well, we figured insurance was going to pay, or because it's always a concern. I think any of us that are going and trying cases against John Doe or whoever it is, the sweet little old lady that ran a stoplight or whatever, it's always a concern. So it feels like great news to know, at least in your case, it never even really came up.
Well, here's something that Judge Pugh did that was, I think, instrumental to all of this. Judge Pugh gave a jury instruction about insurance
Oh,
that
yes.
essentially said, you are not entitled to know about it. Anything having to do with insurance is going to be addressed by me post verdict. Put it out of your minds, because, after every witness, we would get numerous jury questions and they were all about health insurance. And why would they not be?
Right,
Our
right.
case is about the cost of future medical treatment.
Yes.
But we were able to, obviously keep that out. And because there were so many questions about health insurance, Judge Pugh thought it was appropriate to give that jury instruction. And I really think that helps soften the ask of a really large verdict against an individual defendant.
Yeah, I'll just add my own personal experience is the same in that every time we've been able to get an insurance type instruction, I feel like it's so critical. And so when you have a case like this where you've got a bunch of future medical, it's obviously right on the tip of their of their minds. Isn't health insurance going to pay for this, et cetera? So you get one question from the jurors, and then it's like, okay, their judge is not going to answer that. And then right then and there, you sort of have your green light to get the instruction at the end of the case. Phenomenal.
Well,
Yeah.
and something else that the instruction lets you do too, once insurance is in the jury instructions, you get to argue that instruction at closing, which we did.
Yes.
And
Yes.
so we brought that up in closing. We said, here's the instruction. We're begging you to follow this instruction, because if you do not, it is very harmful to the people in this courtroom for you to assume any type of insurance exists in this case. And so we kind of hammered that away in closing as well. And we're like, well, if the court mentions insurance, it's in the jury instruction, then I think we can argue the jury instruction in closing.
Wow. Well, I just have to say that this is a complete master class on how to handle one of these cases start to finish, how you all worked the case up before you filed, how you met with your doctors, how you presented this case at trial. So just kudos to you and your team for this amazing result. And I can assure you, I have learned so much, not only about the medicine, but truly how to properly work up a case before you put it into litigation, and having your team on board and knowing exactly what you're going to do once you get to litigation, and maintaining your credibility throughout the entire trial, where you get up in Adams County and you're like, look, the future meds in this case are 7.1. And they're like, okay, it's 7.1. So just phenomenal, phenomenal result. So Liz, Melissa, thank you so much for coming on the show and sharing your wisdom. I can't wait to hear about your next amazing verdict, because there is no doubt going to be another one in the very near future coming your way. So thank you both for coming on the show.
Oh, thank you, Keith, for having us. It was such a pleasure.
Thank you so much, Keith. Really appreciate it.
Thank you both. Thank you for joining us. We hope you've gained valuable insights and inspiration from today's courtroom warriors. And thank you for being in the arena. Make sure to subscribe and join us next time as we continue to dissect real cases and learn from Colorado's top trial lawyers. Our mission is to empower our legal community, helping us to become better trial lawyers to effectively represent our clients. Keep your connection to Colorado's best trial lawyers alive at www.thectlc.com.